Ginsburg, I just have two clarifying questions.
Yes, Your Honor.
First concerns one of Justice Thomas's question. I know you resist the notion that C1 applies and the reasonable time limit, but you didn't make any argument under that here, as I see it. So we don't have to decide in this case whether, if C1 applies, you did in fact proceed in a reasonable time. Is that correct?
Yes, Your Honor. We believe that, again, if a judgment is void ab initio, then the reasonable time.
I appreciate that, but the alternative argument is not before us that you complied with C1, right?
That's correct, Your Honor.
Okay, and then if we were to rule against you, and I know you resist that,
yes.
Would your client be able to file a D motion, collateral attack to the judgment?
Justice Gorsuch, the
D1.
case law on Rule 60 D1 is a little sparse.
I'd agree with that.
So I would say that the usual scenario in which a Rule 60 D1 motion is filed is when somebody has run out of time to file a motion under Rule 60 B1 through 3. And so I think if the court were to disagree with Coney Island's position, then that would be the end of the case because, well,
you
I guess
really want to give up the D1 argument?
I guess it would depend on exactly what the court's holding is. So if...
How would you have us write it to preserve that option for you?
I guess I would request...
if you want to preserve it.
I would always want to preserve it. But I would write it respectfully. I think the court should write it as saying that the reasonable time limitation in Rule 60B4, the reasonable time limitation in 60C1 does apply to 60B4 motions, but there is also a time, there is otherwise no time limit under Rule 60D1.